Hello, welcome to another edition of Matters of Law. Matters of Law, the law reigns supreme. I believe you've enjoyed our previous editions and you continue to share this with others. Today, we're discussing a dispute between an employer and employee. What issues arise? Let's go for a spot of commercial. We'll be right back.
This program is brought to you by PEG Enterprise. Call us on 0240 533 097 0240 533 097 for your delicious pastries, cookies, and drinks. Locate PEG Enterprise near KK House in Ho.
Thank you. Employer-employee relationship and disputes arising. Now, it is important for every employee or every prospective employee to understand that the employment relationship is governed by an employment contract. So you'll be given an offer letter if you are given an employment. That's what people refer to as what? Your contract of employment. So do you have an appointment letter? Do you have an offer letter? What does it say? What are the terms and conditions? It is important for you to read the appointment letter or the offer letter and know what the terms and conditions are. Your salary, your allowances, disciplinary procedures, and everything that governs how you're supposed to relate with the employer would be stated in that particular document. If you're working for anyone as an employee and that document is not there, you do not have a letter of appointment or you do not have an offer that you have accepted, then you don't have a problem. Because if any issue comes up, you will have a difficult dealing with the issue because you do not have a document that binds your relationship. Having said that, if you have your employment letter or you have your offer letter and you have indeed accepted, it is important to keep that offer letter or to keep your employment letter at a very convenient place so that you can always make reference to it. You can scan your offer letter, you can scan the various documents that come with your employment letter and send it to your email. Once you do that, you can always make reference to it whenever you need it. The next thing you talk about is the conditions of service. Now, the conditions of service may be governed by what we call a CBA, that is a collective bargaining agreement. Now, that collective bargaining agreement is what may be for the various employees who belong to that particular grade that you belong to or belong to that particular unit. Now, you need to know, or you need to understand, or you need to read the terms and conditions in your collective bargaining agreement. That will tell you what you're supposed to do. There are some jobs which also give you a manual regarding how your employment issues are supposed to be governed. For example, disciplinary issues and procedures and reporting channels. You need to know all of this so that when there's any dispute, you know if your employer is going according to the manual. It is also important to know the terms and conditions of your work so that you do not falter. For example, if you're not supposed to drink alcohol and you go and drink alcohol, obviously you'll be flouting the terms and conditions of that employment, and that will land you in a dismissal or any other thing. If you misuse the equipment or any document of that particular company or that institution, you could be sanctioned. And it's important at this point to talk about the disciplinary procedures. Now, when there's any disciplinary procedure, first of all, it may start with a query. Whenever you receive a query, it is advisable that you seek the opinion of a legal practitioner or a lawyer to advise you as to how to respond. Quite a lot of people would write accepting their faults when indeed they may not be at fault. These will be put up in your file and may build a case against you. The other one is if any punishment has always to be affected to you for you to be dismissed, then the offense you have been committing must be very grave. And the natural requirement is that you go through a disciplinary hearing. And that disciplinary hearing must be fair. You should be told your charge that is against you, given ample time to be able to put your case across, and after which the disciplinary body will give a decision. The body that is composed of, or the disciplinary committee, would also have to be as provided for in your collective bargaining agreement or the manual that guides the work that you do. It is important to take time to study all these matters so that you are abreast with the terms and conditions of your work, and whenever any dispute arises, you go according to the terms and conditions. And you as an employee, you have a duty to ensure that the best interest of the employer is always upheld. And as an employer, your duty is to ensure that your employees are safe and they go according to all the necessary conditions that you have stipulated in your manual that guides them. If you do not have an employment contract, please do get one now. If you do not have a manual, please do see a lawyer so that you can get one. Thank you for watching this edition of Matters of Law. Matters of Law, the law reigns supreme. Catch us another time when we bring you another topic. Watch us on extvgh on YouTube and Explore TVGH on Facebook. Thank you.
To support this program, contact XTV on 024 606 1095 or 050 836 4159 or send us an email to info@extvgh.com.